Good morning. The present judgment which I am going to discuss with you uh, may be helpful in two ways. Number one, the judgment says that for obtaining some permission to run some institutions, suppressing certain material facts would not tantamount for for uh, cheating. That means offences under section 420 IPC. That was one of the point. The other point was uh, whether uh, any person can file 482 CRPC petition, whereas he has to file revision under 397 CRPC. In that circumstance, whether the High Court was right in converting that 482 CRPC as 397, whether it is legally permissible or not, these are the two factors that decided in this case. It is AR 2024 Supreme Court 2237. AR 2024 Supreme Court 2237. Vipin Sahani versus Central Bureau of Investigation. Central Bureau of Investigation seems to have filed a charge sheet for offences under section 420 IPC. Therefore, they seems to have filed an application under 239 CRPC. Accused filed an application under 239 CRPC to discharge him and from the offences 420 and 120 BIPC. So that was allowed. Therefore, after a long time, the CBI filed a 482 CRPC instead of filing 397 CRPC. So the Supreme Court, the High Court has stated that they have got plenary power to convert the 482 CRPC as 397 and set aside the discharge order. But that was then referred to Supreme Court in 2024 Supreme Court 2237. Vipin Sahani another. The discussion and the concept disallowing and setting aside the order of Honorable High Court was that they say when a litigant is bound to prepare 397 revision, so that 397 revision is subject to limitation. Therefore, unless and until that there was an answer for limitation, filing 482 CRPC is somewhat to get over the limitation. Therefore, the High Court was wrong in converting the 482 CRPC petition as 397 CRPC revision. Then they also deeply discussed about getting approval for institute from AICT. There was some omitted to give some information about outstanding bank loan, total land sales. The Supreme Court held that concurrent with the finding of the lower court that did not tantamount to cheating. There was no absolutely cheating. So the section 415 to 420 were deeply discussed at various paragraphs. So these things are, so kindly take down that if the only 397 revision is permissible, there may not be 482 CRPC petition. But sometimes the Supreme Court also cited after discussing with some judgments of Supreme Court, the High Court can convert 397 CRPC petition as 482 CRPC. Suppose erroneously filed against interlocutory order, but not when client is bound to file 397 CRPC. If he files 482, the High Court shall not convert that as a 397 CR. For this limitation period, that was legal discussions were there. Kindly take down. Young lawyers must also take simple facts. For these two concepts are there. Number one, suppressing material facts or not furnishing some facts is not cheating. Number one. Number two, that when client when 397 revision must be filed. If 482 CRPC is filed, that has to be rejected. So these are the concept. Best wishes.